Hello! You found the Alliance Educational Series. In this collection, we help you understand how to make sure you are signing a fair contract. In many other videos, we've mentioned the term contract breach fee. In this module, we provide more detail on breach fees. First, we define breach fee and explain its use. Second, we explain how these fees are calculated. And third, we'll end the module by discussing fair breach fees, and we'll offer some strategies to make sure the breach fee in your contract is fair. So, what is a breach fee? While reviewing your contract, you may have noticed that you have to pay a certain amount of money if you terminate your contract early or are unable to fulfill its terms. This is the breach fee, or a dollar amount that estimates the damages caused if one party does not follow the terms in a contract. In general, the party that breaches is required to pay. However, contracts for internationally recruited professionals often include one-sided breach fees. This means that a worker who does not follow the terms will be responsible for paying, but if the recruiter or employer breaches, they do not have to pay. The one-sided responsibility reflects the fact that recruiters and employers often pay the cost of sponsoring a professional through the recruitment and immigration process. But a one-sided fee also highlights the importance of making sure you sign a fair contract and choose an ethical recruiter. The breach fee is a dollar amount to pay if you quit before the end of a contract. So, how is the amount determined? Fees are commonly calculated in two ways. First, they could be calculated to cover recruitment expenses. These are costs that a recruiter or employer pays to sponsor a professional through the immigration process and help them transition into the United States. These expenses might include recruitment, immigration, and licensure costs, exams or test preparation classes, relocation and meet and greet costs, other training and education, or administration and support processes. Staffing agencies that employ migrants directly and contract your work to a hospital or health facility could calculate a different amount to estimate their lost profits. This is the profit your recruiter would have made if you had not terminated your contract early. Lost profits are calculated using the number of hours, days, or years left unfulfilled when a contract is broken. Your breach fee can only be calculated to include recruitment expenses or lost profit, but not both. Whether a breach fee is calculated to cover lost profits or recruitment expenses, recruiters can also charge interest. Interest is a price paid in addition to the principal, the main dollar amount listed. Interest is usually expressed as a percentage over a period of time, such as 1.25% monthly or 3.47% annually. This tells us what fraction of the principal will be added and how often a new amount of interest is added to the principal fee. Here's an example of the calculations. Let's imagine the breach fee listed in the contract is $12,500. The contract also states that the interest rate is 2.97 APR, which stands for annual percentage rate. It means each year, 2.97% of $12,500 would be added to the fee. In the first year, that means $371.25. In the second year, the amount of new interest added would depend on how much of the breach fee and interest had been paid off. So, what's a fair breach fee? Breach fees range from $0 to $800 and $15,000 to $30,000. In extreme cases, we have seen breach fees as high as $60,000. How can they be so different? First, the recruitment expenses the fee covers depend on the recruiter or employer you work with and the services they provide you, your visa type, your profession, how far along you are in the recruitment process, the time it takes to complete the immigration process, and more. Second, staffing agencies have different agreements with each partnering healthcare facility, so their profit is different for each position and professional. No matter how it's calculated, the breach fee in your contract should be reasonable. That means a fee should be very close to an employer or recruiter's lost profits or recruitment expenses. In the United States, it is also important to know that breach fees cannot be used for a punitive purpose. In other words, as a way to keep you at your job against your will. The problem with high breach fees is that they can make you feel that you can't terminate your contract early. Let's look at a real example. In the early 2000s, a businessman named Kizzy Kalu owned a staffing agency called Foreign Healthcare Professionals Group. He began recruiting nurses to work in the US as instructors and supervisors at Adam University. They each paid over $6,000 to obtain their visas. Once they arrived to the US, they learned that Adam University did not exist. Instead, the nurses were put to work in long-term care facilities and were paid less than half of what they agreed to in their contracts. They were also threatened with deportation if they told anyone. The nurses thought about leaving their jobs, but their $25,000 contract breach fee meant that they could not afford to do so. In 2012, Kizzy Kalu was found guilty of 22 counts of trafficking and forced labor, in addition to another 67 counts of fraud and money laundering. In this case, each nurse's $25,000 breach fee, when combined with lying and the threats, helped the courts to decide to sentence the recruiter to many years in prison. Not all international recruiters use breach fees. In fact, research shows that they are more commonly included in contracts for people in low-income countries. If you are offered a contract with a breach fee, there are 3 strategies to make sure your fee is fair before you sign. First, read your contract carefully. Identify whether a breach fee is included, and then how it is calculated. You can ask if the calculations are clearly described. Is the purpose and amount explained? Does the fee cover only recruitment expenses or lost profits? Is it a reasonable estimate? If you're unsure if your breach fee is reasonable, you should feel comfortable asking your recruiter for additional information and for a breakdown of how it was calculated. If your recruiter or employer is not willing to negotiate and lower your breach fee, or cannot provide you a breakdown of how it was calculated, then consider a second strategy. Look for different recruiters before you sign a contract and compare breach fees from different companies. Is your fee much higher than other similar contracts? Does the fee drop based on how long you stay at your job? Does it accrue interest? If your breach fee is much higher than others, or if you do not believe your fee is reasonable, then you should consider working with another recruiter. Third, ask a lawyer, your union, your home government to help you understand your contract and its breach fee. The Alliance can help you find lawyers and organizations that will help you for free. You only want to sign if you are serious, committed, and satisfied with all the terms, including the breach fee. So take time to ask questions and ask for help. What happens if you've read carefully, negotiated a breach fee, and still don't like the contract? That's okay. Refusing to sign with the first recruiter or employer you meet does not mean that you will not be able to get a job in the US. In this module, you learned that signing a contract with a breach fee means agreeing to pay a certain amount if you break your commitment early. You learned why recruiters use breach fees and how they are calculated. You know now that the United States does not allow these fees to be used to punish employees or to force you to stay at your job. And finally, you know 3 key strategies to determine if your breach fee is fair. The Alliance is here to help. Please watch our other videos in this collection on signing a fair contract, and visit our website to find more resources. Let's test your knowledge. Which of the following statements is false? A breach fee is a dollar amount that estimates damages caused if one party does not follow the terms in a contract. Breach fees can be calculated to include recruitment expenses or to cover lost profit, but not both. In the United States, a breach fee over $15,000 is not legal because it is never fair or reasonable. Very high breach fees can make migrant workers feel trapped in jobs that do not work for them. Some contracts include one-sided breach fees, meaning a worker who breaches will have to pay, but an employer or recruiter who breaches will not. The correct answer is C. In the United States, there is no specific number or dollar amount that helps the court to determine whether a breach fee is fair or reasonable. Legal breach fees cover a wide range.